Arrest them all. 3 words, spoken by a federal judge, on the record, in open court. According to newly released transcripts, Judge Caldwell didn't ask. He didn't suggest. He ordered it. For 18 months, Caldwell had been buried under 114 allegations, a coordinated avalanche meant to erase his career, his reputation, his life. Then, everything collapsed. One witness flipped, one recording surfaced, and the entire case imploded. But the most unsettling part isn't what happened to Judge Caldwell. It's where the paper trail leads. According to court filings obtained this week, the evidence doesn't stop with a rogue witness or a corrupt prosecutor. It points directly to political operations connected to J.D. Vance's office. This isn't just a legal scandal, it's a constitutional shockwave. What triggered the order, May 7, 2025, 9:47 a.m. Eastern, Federal Courthouse, Room 4B. Judge Caldwell entered the courtroom calm, almost eerily so. Witnesses later described him as controlled, silent, focused. The prosecution team, 6 attorneys representing what filings identify only as the opposition group, appeared confident. They believed this was the final act. They were wrong. At 9:52 a.m., Caldwell's attorney requested permission to play newly submitted audio evidence. The prosecution objected, 4 times in under 2 minutes. All 4 objections were overruled. Then the recording played. According to the official transcript, the courtroom heard a voice linked to a senior coordinator discussing specific witness payments. $340,000 to witness 7, $275,000 to witness 11, $890,000 to witness 14. But the money wasn't the most damaging part. At the 1:42 timestamp, confirmed by 3 independent forensic analysts, a second voice enters the conversation. This voice discusses a $4.7 million budget labeled narrative maintenance. In plain terms, they weren't paying for testimony. They were buying a conviction. The prosecution went silent. The lead attorney asked for an immediate recess. Denied. Because Caldwell's team wasn't finished. The flip that changed everything, witness 14, whose identity remains sealed, had recanted every statement made over the previous 18 months. But this wasn't a sudden change of heart. The witness arrived with evidence, bank statements, encrypted messages, transaction metadata. A detailed timeline showing coordination 7 months before the first allegation was filed. This wasn't prosecution. It was an operation. A former court reporter present that day described it simply, "I've been in courtrooms for 30 years. I've never seen attorneys physically unable to respond. They just sat there." The silence lasted nearly a minute. Then the next revelation detonated. Following the money. The filings showed that at least $2.1 million in witness payments originated from accounts tied to political operations connected to J.D. Vance's office, routed through shell companies between January and April 2025. The courtroom erupted. Judge Caldwell stood, not the visiting judge, Caldwell himself. And according to the transcript, he said 4 words that are now echoing through Washington. Arrest them all. Not a request. An order directed at the U.S. Marshals in the room. Everything changed. The ruling. At 10:23 a.m., after reviewing the evidence for nearly 4 minutes, the visiting judge ruled. All 114 allegations against Judge Caldwell were dismissed with prejudice. The charges can never be refiled. The court found sufficient evidence of fraud upon the court. 6 individuals were detained that morning, including the lead prosecutor. But what most people missed was this. The audio metadata had already been forwarded to federal investigators, specifically FBI counterintelligence. Because when financial trails intersect with political operations tied to a sitting senator, it stops being a courtroom issue. It becomes a national security matter. The pushback and why it matters. Supporters of the original prosecution argue this was a distraction, even potential witness tampering. And that argument isn't frivolous. Witness recantations happen. Audio can be manipulated. But here's the problem. The financial records, metadata, and timelines don't rely on testimony alone. They corroborate each other. Legal analysts are blunt. If the tape is real, this is one of the worst prosecutorial scandals in modern history. If it's fake, Judge Caldwell committed multiple federal crimes in open court. There is no middle ground. Someone is going to prison. The bigger question: 18 months before the collapse, warning signs were already documented. Internal memos show irregular case routing complaints clustering unnaturally. Discovery requests repeatedly denied. One former court administrator put it plainly: allegations don't cluster like this organically. Either someone was committing serial misconduct, or someone was manufacturing a record. No one acted. Until witness 14 walked in with receipts. Where this is headed. A federal grand jury convened the next day. Preservation orders are pending. Subpoenas are already moving. And here's the detail that has investigators most concerned. The FBI's counterintelligence division doesn't get involved in ordinary misconduct cases. That suggests the money trail may cross borders, or involve actors far beyond a courtroom. Judge Caldwell is reinstated. His name is cleared. But the investigation is just beginning. This wasn't the climax. It was the opening statement. And the question now isn't just who paid the witnesses. It's who told them to.